was brought up in the Upper Great Southern, Narrogin in Western Australia, and I've always been a country boy and been around farm, rural agribusiness all my life. Got one sister, she still remains in Narrogin, and she took a career in the medical industry, and she's actually pretty much the head matron of the whole Upper Great Southern and Regional District, so she's done very well for herself. My father was a private wool buyer for many years. His father owned a farm, and my mother she was one of 5 sisters, came off a farm in Kojonup, which is also more so in the Lower Great Southern. And yeah, she was one of 5 sisters, and they all worked on the farm. My parents have been very supportive and got that real country ethics and family commitment. Went to school, Narrogin Senior High School. My parents did try to drop me off to boarding school. The day they dropped me off was the day I left, and then they went to drop me off the very next day, and I left on that day as well. And then they found that they couldn't keep me there. I wanted to go back to the country and be with my friends and be with my family. Always been very dedicated to Aussie rules footy, played in the WAFL. Unfortunately, my career ended early through knee reconstructions. Footy was a big part of my life, certainly country footy. It was something that was well accepted right throughout the region and the community, local communities. Got into politics more so unintentionally would be the best way to describe it. I was witnessing things that I certainly acknowledged that we were all living in Australia, but what was being carried out was un-Australian, and it was that part of the being un-Australian that led me to politics in a sense, because I could see how certain members of the community were being treated by the big end of town. And I certainly, after the global financial crisis, with the way farmers were being dispossessed of their properties, was certainly un-Australian, and it was through that I wrote terms and references to a Senate inquiry at the Novotel Wentworth in Sydney. Those submissions were accepted and I addressed a full bench there, and at that hearing I was actually commended on the submissions. I was heavily cross-examined by senators, and in particular Senator Wacker-Williams from Inverell for the Nationals, and it was at that presentation or that Senate inquiry that Pauline Hanson approached me and said that I needed to run and be a senator for Western Australia and for the farmers. And I basically said to her, you could pay me $1 million and I wouldn't be a political tosser. And from there things developed, and I needed that platform, and basically I accepted the offer from Pauline Hanson. She offered me the portfolio of running a Royal Commission into the rural industry, rural banking, lending facilities, and I accepted the offer. It started off well, and then when I started to really apply the law and the Royal Commission Act to get the executive power in order to have a bona fide Royal Commission, that's where I saw the departure from our real law, which is the executive power which is granted at Federation. And as I kept asking questions and applying that to empower the terms and reference right to Malcolm Turnbull and so forth, that's when I was being confronted with, there was a kickback not only from my party leader but the Attorney General and Malcolm Turnbull himself, which became very concerning to me. Once we're elected as a federal senator, we have to undertake a Senate induction, and that's where we all sit down in a room and the clerk of the Senate addresses us and basically gives us an overview of our history. Now, history was something that I loved at school, and certainly once that constitutional history and the effects of federation and what our war servicemen and women fought for, I absorbed that like a sponge. And I am an inventor. I am listed on IP Australia. So I understand concepts. And once I started reading our Constitution, which is our founding deed of this great nation and the apex law of that runs this great country, I was able to understand the concept and followed that concept. And that concept needed a head of power, and that head of power had been removed in 1973 by a new creation of a corporate queen called Queen of Australia. And there are certain sections within the Constitution that grant powers to the Parliament, and there's about 20 sections, and what that requirement is not put in the first covering 9 clauses of the Constitution. So the Parliament does not have power to alter, or a stream can't rise above its source to remove or tamper with the executive power which comes down through the sovereignty of the United Kingdom. Section 128 calls a referendum, so the people must be informed and briefed if there are to be any changes to the Constitution, but that can only be effected between sections 1 and 128. The first 9 covering clauses are unalterable, so they're cast in stone.
I'm Darren Dixon. I'm a researcher for the Great Australian Party. I've been studying constitutional law since 2007. I have continued to study constitutional law and have been assisting Rod and the party with research since 2018 with a good friend of mine, Neil Pitchanen, who is my mentor and good friend, and also involved with the Great Australian Party. So the Constitution is the establishing act for the Commonwealth of Australia. It was established in 1901, the 1st of January, and it's a British act that brings together 6 colonies to become states to unite in one federal indissoluble Commonwealth. The Constitution was created over about a 10 or 12 year period. There were various conventions around the country that established the fundamental principles and the provisions of the Constitution. It was then sent to England, and Queen Victoria, actually provided the royal assent for that particular document, which basically brought it into Australian law. Can the Constitution be changed? Well, if we look to the previous referendum, the Voice referendum, most people will understand that it is only the sovereign body of voters within Australia that can change the Constitution. We all come together and we vote for those changes. So fundamentally, it is only the Australian people that can change the Constitution. That is because at Federation, parliamentary sovereignty was thrown overboard, and it was the people of Australia that became sovereign. Now, there is one other way to change the Constitution. In 20 sections of the Constitution, there is a command which says, until the Parliament otherwise provides. And that gives the Parliament a direction to change those particular sections of the Constitution, and they're on subject matters such as the Governor-General's salary and things like that, and the amount of people who can sit in each house. So they are the things that the government can otherwise provide in the Constitution. Essentially, the changes to the Constitution have been occurring since 1926. The Constitution itself does not reflect these changes within its pages. What I'm trying to say is that the Australian people have not been asked for their permission to change the Constitution, and the political parties have been doing these changes fundamentally without any consent of the Australian people.
So on the 29th of August 2016, I sat right in this very place, which I am to understand was at the seat of independent Harradine, a senator from Tasmania. Ironically, it was one day before I took my oath to the Commonwealth of Australia. Above my left shoulder is the crest, the true crest that empowers the House. This is the High Court of Parliament. As you can see here, our reigning monarch sat in the chamber. What I'm standing next here is a replica of crowns of our previous monarchs, but most importantly, to the right of me, is the coronation crown, which is the protection of our freedom and rights, and that is displayed right here in this cabinet. Well, it all started in 1953 off memory. That's when the first introduction of a corporate queen started to appear. And then in 1973, there was the Royal Styles and Title Act of 1973, where Gough Whitlam removed the Commonwealth and so the executive power of the United Kingdom, because one has to remember that the Constitution is a British Act. It's a United Kingdom Act. It's an act that's passed by the British Parliament. And he removed the words Commonwealth, so he took away the authority without the awareness, being made aware to the Australian people. So basically he removed our sovereignty and our rights and then replaced it with a corporation which can only give you privileges and not rights at all.
In 1973, the Whitlam government brought about a scheme to remove the Crown of the United Kingdom as the authority within the Constitution. And they created a localised Queen. This process began in 1953. In 1952, there was a meeting in London, an economic meeting between all of the representatives of each of the dominions in the Commonwealth. And each of these members decided to divide the crown. So in other words, it was to create a localised crown for that particular place. So all of a sudden, from 1953, instead of there being one indivisible crown over the empire, what we had was an individual crown for each nation. And they created the Queen of Australia, the Queen of Canada, the Queen of New Zealand, and so on. So effectively, they removed the power and authority of the British Crown and they inserted a local power. The question is, what is this power and who is exercising it? Who is the Queen of Australia? Well, fundamentally, there is no Queen of Australia. What there actually is a piece of legislation which creates a title for the Queen to adopt for use in relation to Australia and its territories, that being a geographical location. Previously, the title for the Queen applied to the Commonwealth of Australia, which was the political union of people who united at federation. So one applied to the Union of People of Australia, and the new one applies to the geographical location being Australia. So after the demise of the Queen, we now have King Charles III. To date, the Australian government have failed to create a new title for the King to adopt for use in relation to Australia and its territories. So currently, one would say that we actually don't officially have a head of state. Now, previously, when the crown was indivisible, so there was one monarch over all of the different realms, the monarch ruled absolute. And when the monarch changed from one monarch to the next, the powers and authorities changed also. But now that the king's title has been divided, what we find now is, although the title transfers, fundamentally, for it to be exercised in a local capacity, there has to be a piece of legislation to allow for that. Because it's simple as this: the king clearly cannot adopt his mother's title, because that title is unique to his mother, Queen Elizabeth II.
In effect, what was done was unconstitutional. It was done by the Labor government beyond power, and if it's beyond power, it's void. So, of course, that has an on-flowing effect, because basically now, because we've removed ourselves away from the executive power and we've come out of the Commonwealth, there's no head of power to create a new Royal Styles title for the King of Australia. So the Senate is in a logjam at the moment. They're not trying to bring attention to the public, but basically there's completely no rudder left on the boat because there's no power to do anything. So effectively what's happened is the Parliament has gone off the grid, and they've got a little 1 horsepower generator puffing away at the back of the building, purporting to hold power, and it's beyond power. So 1973, once you go out of a law that has been ratified by the Australian people at Federation, and you're not running under that law, you're no longer in a state, you're no longer, you're in no man's land, and that's what's happened to Australia, and that's what I spotted. So there's a serious jurisdictional issue currently playing out at the top end of town.
I call Senator Cullerton.
Mr President, I stand here in this chamber today to present my inaugural speech on oath to deliver my message to the Australian people. What follows will be the truth, the whole truth, and nothing but the truth, before Almighty God and the people of Australia. I want my actions in this place to reflect my own personal experiences. My inaugural question to the Senate on the 12th of September of this year was to the Honourable Attorney-General and concerned the inconsistencies and the unconstitutional behaviour of our courts. I have started in this place, as I mean to go on, with my inaugural question aiming right at the middle stump on constitutional issues. That question was unprecedented and referred to the High Court Rules Review Committee. It is on notice that Dennis Lilly wasn't the only best bowler to ever come out of Western Australia. Mr President, the hunted has now become the hunter. Australia is not running on all cylinders, and it is desperately in need of a tune-up. To simply put the blue flame out and just simply put it into overdrive. This will be done with the support of my team in Western Australia and those of my colleagues who are prepared to put the best interest of this country first. The reality of Australians today, however, is that the fight is not being carried out on a level playing field. It isn't fair, and the battle is too often against our own governments and those who purport to uphold the laws. For too long in this place, successive governments have defied the Constitution our nation was founded on, and in doing so have ignored their duty of care to the people of Australia. Australians are defenders and upholders of the Constitution and our laws, not a global government pushing UN dictates where undermine our sovereignty. It is long past time for an Oz exit from the UN and removal of all its shackles. Agenda 21 demands such a deregulation or removing the laws that have provided ethical guidance for foreign corporations in this country, adopting the attitude that they can do, seeing this in our banking institutions. We live in your world, in dealing with their clients, as recent inquiries have exposed and is still being ignored by this government. Did the government take the proposal to a referendum as demanded under the Constitution? No, they did not. It appears that all major parties live in hope that the Australian people will abandon their present democracy and their constitution and let today's politician formulate a new constitution based on the very impost that they already forced on the people of this nation, in breach of our constitutional rights, and all done without the consent of the Australian people through a referendum. When I attended Senate school recently, I was handed a Senate pack which contained a pocket edition of the Australian Constitution with the overviews and notes by the Australian Government Solicitor. Due to certain disgruntled malcontents trying to remove me from the parliamentary poker table through section 44(2) of the Constitution and challenge my validity to stand here today as a senator in section 9 under disqualification, I began to read out and appreciate just what a powerful document our Constitution really is. It is the foundation document of our nation and clearly constitutes the Commonwealth of Australia. As raised in my inaugural question in this chamber, our courts have sidestepped their responsibilities under the Constitution and are currently acting in defiance of the foundation rule of this nation, the Constitution. I stand humbled and honoured to have been elected to this place and make a commitment that I will continue to defend and uphold the Australian Constitution as an elected senator. This nation stands at a minute to midnight, and our obligation to future generations is no less than those who have gone before us and were prepared to do for us.
In Rod's maiden speech to the Parliament, Rod raised the fact that the Queen had been removed from the High Court rules.
Mr President, one question to the Senator, the Honourable George Brandis, QC Attorney General and Leader of the Government in the Senate. Since Senate School, it has come to my attention that there is a discrepancy between Section 33 of the High Court Act 1979, which says that all process shall, which must, be issued in the name of the Queen, and the High Court rules of 2004. If this appears to be the case, why has the High Court felt free to defy the Parliament for 12 years?
The Leader of the Government in the Senate, the Attorney-General, Senator Brandis.
Well, thank you. Thank you, Senator Culleton. Congratulations on your inaugural question in this chamber. Mr Phelan has responded, and he has advised that the High Court's Rules Committee wants to have a look at the question, and that will probably take place at the next meeting of the High Court's Rules Committee in October. If I may say so, Senator Culleton, it is very, very unusual, if not unprecedented, for a senator's question to find its way onto the agenda of the Rules Committee of the High Court of Australia. And I'm sure it is utterly unprecedented for a senator's inaugural question to do so. Thank you, Senator Culleton.
All matters in the High Court must be brought in the monarch's name. They'd completely removed the monarch from the High Court rules, and matters were not being brought in the name of the monarch. Once he raised this question, this was put to constitutional experts and the High Court, and they came back and they said yes. Mr Culleton was correct. They should not have removed the monarch from the High Court rules, and that all matters must be brought in the monarch's name.
Silence, all stand. Please be seated. Silence, all stand. The Court of Disputed Returns is now in session. God save the Queen.
Senator Culleton, it was you who spotted this discrepancy. It was you who spotted the discrepancy in the High Court rules, which the High Court Rules Committee has now acted upon. I might say, since those rules were promulgated in 2004, there have been 16 distinguished Australian jurists sit on the High Court, including 2 Chief Justices. And I must congratulate you, Senator Culleton, on being the first person to spot the problem.
The Constitution is still valid, still real. The Queen is... I interviewed Professor David Flint last Saturday on my show on TNTRadio.live. He confirmed that the Constitution is real, it is solid. We're effectively a republic with a president in the form of a Queen that is appointed by our Parliament.
So this sent a spiralling effect upon Rod himself because he exposed the fraud of these slow incremental steps over time, so gradualism, to change the power and authority and to remove the monarch and to create a de facto republic. Rod, upon exposing this anomaly, set off a crescendo of events that eventually had Rod taken out of the Parliament. So for his exposure of the Parliament removing the Queen from the High Court was to Rod's detriment, because he was not going along with the fundamental plan to remove the monarch and to create a republic.
How did this all come about? Because I wrote the terms of reference to the Royal Commission, you need the executive power. So to have a Royal Commission to have any Royal Commission, you rely on the Royal Commission Act of 1902, which is 2 years after Federation. And the executive power is derived from the letters patent and from the second clause of the Commonwealth of Australia Constitution Act, which means the power comes from the Queen or King of the United Kingdom. So in effect, we all hold a letters patent, and that patent gives us the protection under the Crown and allows us to become bona fide Australians because the law puts us there. It's our founding deed, it's our title deeds to our country. So when there is no power, there is no power. It's as simple as that. So how this all came about, I had to empower a Royal Commission. So I wrote the terms of reference for the Royal Commission. I presented them to Malcolm Turnbull, and I pointed out to Malcolm Turnbull there is a conundrum, and he said, "What is the conundrum?" I said, "It's found at 1A of the Royal Commission Act of 1902. That power is an executive power, but it's only granted to a Prime Minister of the Commonwealth of Australia. It cannot be granted to any other Prime Minister that holds an Australian Parliament. That is beyond power," and that's where the issue started to arise and manifest.
We're not having a banking Royal Commission.
There's nothing more than crass populism seeking to undermine confidence in the banking and financial system.
Malcolm Turnbull was caught between a rock and a hard place because he was put on notice that the whole Parliament was out of jurisdiction, was being run by a corporate Queen and not the sovereign Queen, that in actual fact all the sitting members, in effect with the Citizenship Act of 1948, current sitting members were all sovereign citizens in a jurisdiction not recognised by our foundation law. And once Malcolm Turnbull was made aware of that, he in effect had to step down as a Prime Minister, because once you are of knowledge of a potential wrongdoing, if you act beyond that, then you may be subject to a criminal offence.
A political withdrawal on the banks.
Only the government can ensure that a Royal Commission is created with responsible, comprehensive terms of reference.
Having argued against one for 2 years, voted 22 times to prevent one, and just Tuesday insisted,
We have made it very clear that we are not going to establish a Royal Commission.
Today he did.
Government's policy remains the same until it's changed.
A special cabinet meeting approving the decision after receiving a letter from the big banks requesting an inquiry, what the Treasurer calls
a regrettable but necessary action.
The 12-month inquiry costing $75 million will hear complaints from individuals, businesses, farmers who believe they've been dudded by the banks and decide whether compensation is necessary.
It'll cover the nation's banks, big and small, wealth managers, superannuation providers.
Well, Morrison continued on, but unfortunately I was not on the platform to come back after Christmas break when the Parliament was on its break, and he continued on because basically he hadn't been put on notice. Yeah, I put the Clerk of the Senate on notice. She stood down. The High Court of Australia was put on notice. The Chief Justice stood down. The Principal Registrar stood down, and it was the the match in the grass for getting rid of the dual citizenship within the Parliament. On the 1st of December 2016, with the support of Senator Jackie Lambie, I filed a motion 163 putting the Senate on notice, calling the Attorney-General George Brandis and my former party leader Pauline Hanson back to explain how the whole government could run under a corporate title called Queen of Australia and where did it get its power from. Look, they've pretty much kicked back very hard. The Australian Electoral Commission has in effect prevented me from going in a new election without coming out publicly and saying that I'm not qualified to do so, which I certainly rebut that. So I've faced a lot of headwinds and log rolling to try and get there, and a wrongdoing cannot continue on. There has to be a remedy, and law affords that. And if we apply the right law and get within the jurisdiction, we will get victory. Where it sits now is I'll represent myself in the next up and coming election, and I will continue on doing what needs to be done for the best interest of all Australians. I was there for a 3-year period, but just pretty much after 12 months, I was prevented from returning back to Parliament by a president that was not lawfully sitting also, and ended up getting him removed as well. So although it was a real endurance, there was a positive side to it, because as I started to apply the law around my own circumstances, being a federal senator, I was starting to take a lot of scalps with me. And that needed to happen to give awareness to the Australian people. So in 2011, it was declared that no more applications could be made to the Privy Council in the United Kingdom, because Australia was going to deal with its own laws. However, that was just a nonsense. I was able, in 2020, I was able to file a High Court application in the United Kingdom. Although the United Kingdom at first, through the registrar in that court of the High Court of Chancery, said, "Oh, Senator Culleton, we cannot hear a matter under Australian law." And I basically came back with the answer. So this is not an Australian law matter, this is a Commonwealth of Australian law matter. And they said, yes, we have jurisdiction to file it. And I successfully filed it, which went against what our government was telling us.
In the late 90s, Kim Beazley said to Parliament that there is a mandate between the United Nations and the Australian government that when a republic is proclaimed, that the Australian government will have power and ownership over our homes, our businesses and our farms. Essentially, this is what the government are working towards. Rod's goal is to stop this. Rod's goal is to bring back rule by the people within Australia, because at the current time, in the current mood, what we see is political parties pushing political party agendas and not the wishes and will of the people of Australia. Some examples of this would be the Misinformation Disinformation Bill, the removal of manufacturing in Australia over the last 35 years, the digital identification schemes that are being brought in against directors of companies and also against Australian people. Fundamentally, people are being told that unless they adopt these security measures, which we all know are very unsecure, that they cannot access these particular services. So these are just a few of the examples that are happening on a state level as well. The governments are working towards basically criminalising virtually every act that you do. So whether that be on an individual level or on a family level, there seems to be a fine for everything. And this is the direction that the government are taking us.
So I've come down to Colin John's farm in Moondarra in Victoria today to follow up on a story that I found out about a couple of years ago with regard to chemicals that are being used on this land. Land where Australian farmers were actually forced purchased to get off their land and out of their farms after farming them for absolutely generations because of the dam for public water. But then what the Victorian government decided to do was import corporations that grow pine forests, and they then subsequently poison the land down here for those pine forests with Grunt 750 and 1080. So today we're going to talk to Colin about how that affects all of the farms that remained.
My name's Colin Brown, third generation farmer at Moondarra on Browns Road. Basically surrounding properties around here are blueberries to vineyards to beef farms. We did have spuds, we had all sorts of things here, poultry, we had pigs, we had all sorts. Over the years that I've been farming, I've got an organic blueberry farm to my right hand side across Browns Road as you come into this property. The owners are great people, basically look after their land organically, so they don't use any fertilisers and any sprays. I looked at that 30 years ago and I thought this might be the way that I should probably start to steer myself. So I've used less and less each year. Less fertiliser, less sprays for blackberries and thistles. But what we've got in the Moondarra Reservoir, which is run by the state of Victoria again, Gippsland Water, is pine plantation. And the problem that we got with pine plantations, they put fertiliser underneath the pine tree when they plant them. And then usually within the first 12 months they use a chemical. And that's done via aerial spraying, aeroplane from out at Leongatha, which is only 30 minutes from here. And they bring these planes in and they start aerial spraying what they call a Grunt 750. Grunt 750 has been used around the world everywhere, but we're one of around about, I do believe, 7 countries that allow it to be used. Is the fact that the reason that they use this Grunt 750 is it's a granulated chemical mixed with water, and then it's sprayed via the aerial spraying that kills everything bar the needled pine tree. So that means your clovers for your bees, that means your ryegrasses, that means your gum trees such as your eucalyptus, your silvertop that we've got around here, your lightning wood, which is as much as blackwoods, any dogwood, blackberry, any sort of life will die other than a pine tree. It's a bit gobsmacking to say, is it the only thing that kills? Well, no, it doesn't. It'll kill bees, it'll kill tadpoles, it'll kill mosquito larvae in a puddle of water. It'll kill basically anything other than the pine tree. For the community and farming, we weren't consulted at all of what chemicals they were using or what they were actually doing or what day it was going to be used.
The Senate is the highest court in the land. It sits with 76 jurors. It sits under the power of the Crown, and the executive power is given to each and every one of those senators elected through the consent and ratification of the Commonwealth voter. And with that, you sit with more power than the High Court, because it is the people that have chosen you who hold the executive power under the Westminster system, whereas a High Court Chief Justice is chosen by the Parliament of the day. A senator can call upon a judge to attend the chamber if there is sufficient evidence of misbehaviour. Perhaps while the Parliament was sitting under the Commonwealth. However, I do not believe there is any executive power in the Australian Constitution to call a chosen judge to an alternative jurisdiction not sitting under the Crown. The Senate is the watchdog, it is the lawmaker, it is the final filter that has to be put before the House in order for any bill to go off to the Governor-General for assent in order to become law. The House of Representatives debate a proposed new law through a bill, and then it is upon that, when consensus is made, it then goes up to the High Court of Parliament in order to make sure that the democratic process has been fully complied with under law and through the executive power. And upon that, it then gets the House of Review and the permission by the High Court of Parliament, being the Senate of the Commonwealth, in order to send that bill back to the House for its departure to go down to the Governor-General for royal assent. We haven't had a Governor-General since 1973. We only have ever had a Governor-General doing business on behalf of an Australian government. So the question is, has there ever been any lawful bill passed since 1973? The law claims it has not. The Parliament hasn't been acting unlawfully, it's been acting without law. To act unlawfully, you would need to come back under the Crown, under the Westminster system, which was ratified at Federation. And the very house that we went in today was established by our forefathers and ratified, being a United Kingdom Act, in order to become law and run this great nation as the Commonwealth of Australia. However, up in what they claim to be the new Parliament House, there is no reference to the Crown or the monarch or the executive power, and that deems it a corporation. And the laws of Westminster do not recognise the Australian government. Jurisdiction, jurisdiction, jurisdiction. It is the first duty of any court and any power of any country. The voter is being deprived of his wills at the ballot box. What we need to do is have all the corflutes put in English, and we must elect a bona fide Commonwealth officer in order to bring the country back under its jurisdiction, run it under the United Kingdom Act, and get the laws and powers and protection through the Crown. The first 9 binding clauses of our United Kingdom Act are set in stone. And there are 20 sections throughout the Constitution that state until the Parliament otherwise provides. And that is not written in the first 9 clauses. Clause 2 of our founding deed and Clause 5, which were all contracted to the Westminster system, makes it very clear the executive power must be the power of the United Kingdom. Sections 1 to 128 and section 51 are where the Parliament does have power to make law for good order and peace and so forth for under the body politic. Section 128 is where the power vests with the people throughout the Commonwealth in order to call a referendum. No bona fide referendum has ever been held post 1973. Authorised by Rod Cullerton for the Great Australian Party, PO Box 8242, South Perth, WA 6151.